I would just like to make one additional comment on that too. Because I think the other thing that we didn't see in any real IP cases last term, but I expect to see in the next couple of years, is not Justice Kagan. And in fact, certainly you're not going to see anything really important out of Justice Kagan this year because she's had to recuse herself from so many cases. But Justice Sotomayor had extensive experience on the Second Circuit, not with patent cases, but with copyright cases. And so she comes to the court with a very good understanding of intellectual property. And I think if you saw the questioning, if you read the oral arguments, she did probably the best job of directing questions at both sides. Most of the justices pretty much took aim at one side or the other. Justice Sotomayor took good and careful aim at both sides.
Other questions? Yes.
There are a lot of corporations that just buy up patents in order to either protect themselves from lawsuits or make money by suing people for those. And a lot of the patents are absolutely ridiculous. They're raised in the first place. How do you propose that that problem is dealt with?
Yeah, I don't see it as a problem. So a couple of things. If they're a ridiculous patent, they're not going to protect you. So defensive patenting, they're usually pretty good patents. And offensive patenting, patent trolls, as they call it. I'm doing a study on this now where I'm actually studying the patents that they buy are actually pretty good patents. And there's a reason for that. They're trying to make money. And you don't make money on ridiculous patents. And so periodically, the ridiculous patents that come out get a lot of press. By and large, the patents that are pushed that are enforced are very good patents. That's what people are worried about. Now, that said, some people think there's a problem with that. They should be in business in order to protect patents. My view of that is about half of the patents that they're enforcing come from individual inventors. And if you look at a random sample of litigation, individual inventors are almost never plaintiff. And so one way to look at these folks is it's the only real way for your garage inventor to enforce a patent if they can't start their own company. Now, you may like that, you may not like that, but how you feel about the garage inventor is really how you should feel. In fact, that's basically the thesis of the article I'm writing. How you feel about the garage inventor is how you should feel about these patent trolls. That said, some of the patents are overreaching. Most of them are invalid. A study I just read showed that when these cases go to trial, they have about a 10% win rate. So, the bad patents are getting defeated. So I don't see it as a big problem.
I agree generally with that. The really ridiculous patents, the ones of exercising your cat using laser, no one gets sued on those. The other thing with some of the ridiculous patents out there is it's just an artifact of the examination system that if the case goes through and it gets examined for being useful, novel, and non-obvious, and the examiner is limited to the resources they have available in the patent office and the time they have available, some of those things are going to slip through until a good body of art is built up. Once a good solid body of art is built up, then those will then serve as basis for rejection. But again, probably the most successful patent litigator in the last century was a gentleman by the name of Lemelson, who was a patent attorney, and he had a lot of inventions. He was the master of the submarine patent, and what he was able to do himself is what some of the patent trolls are trying to do, is by having a portfolio of patents and having licensing money come in from those patents that they're able to get licensed, then they're able to justify going out and bringing the first couple suits for a garage inventor, essentially. So it does give that person a day in court. One of the cases that's always talked about, we had the movie that came out a couple of years ago, Clash of Genius. You know, there really wasn't a problem with the patent there. If you really look at that case, the difficulty that that inventor had is that he was not willing to license the patent. He wanted to build his own family company that was going to supply intermittent wiper blades to Ford. And think about it, Ford is not going to tie up their automobile manufacturing line on a company that is unproven. They suggested to him several times, if you go to Delco and you license this technology, we'll license the technology.
Yes.
Since about a decade ago, international treaties kind of revamped the patent system. Do you foresee a future international treaty or international pressure will eventually affect business patents, business process patents, if they're done that way? Since Congress and the Supreme Court don't seem like they put international pressure have effect.
Well, there's no bar in the treaties for that particular thing.
Right.
So
In the future, do you think, since we're the only country that does it?
I think this is an area, especially because we're so strong in software, where the lobby is not going to allow that to happen. I mean, it's a very divided lobby you've got. I mean, this is why patent reform can't get through. On the one hand, you've got the IT software saying this patents are awful, and on the other side, you have biotech and pharmaceuticals saying we can't live without patents. And until that gets resolved, there will be no movement, and the IT lobby is not going to even the IT lobby is divided in half, so it's going to be tough. So I think we'll see some movement, but I think in the patentable subject matter, I don't know if we're going to see a whole lot of change. I could be totally wrong on that, obviously. It wouldn't be the first time, but that's just my guess, basically.
I think that if we look back over 200 years of copyright and patent protection, over time both have tended to expand with time rather than retract. In fact, there's virtually no retraction of scope in either of them, and so I would be very surprised to see any change in the future.
All right, last few questions. Somebody? All right, well, I guess we can conclude. I do want to say before you guys get out of here, next week is our bye week, so to speak, in the Federalist Society. We don't have an event. It's the only week I think we've had where we haven't had at least something. But in that week, we will be sending out invitations to our next semester speakers. So if you have any ideas, you have anything you would like to see a debate or an event on, please contact me. You can get to me via the Twin site. And then please join us again next week, following week, for our events that pick up then. All right, and let's give a round of applause to our speakers.
There's still several burritos left, so feel free to take them.
comment that we're not allowed to use accents in our oral argument
Oh, really?
as judges.
Oh, that's ridiculous.
Just imagine when we start talking in Indian accent.
I
have
never
no
heard
idea.
that.
Let it go good. We're not know what they're talking about. Can you please refrain what we're talking about?